Nice brisk day. Good day for an argument. This is cause number OP 19-0085 BNSF Railway versus the Asbestos Claims Court of the state of Montana. Petitioner gets to go first. Mr. Schoengert, are you going to make the argument today?
Good morning, Mr. Chief Justice, and may it please the court. I'm David Schoengert with Crowley Fleck for BNSF Railway Company. I'd like to reserve 10 minutes of time for rebuttal, if I may. The Asbestos Court is proceeding under several mistakes of law in this court in reverse. BNSF did not mine vermiculite, it did not mill it, and it did not load it into rail cars. BNSF only transported the final product as freight that its federal regulator said was not a hazardous material, was not subject to special handling requirements, and that it is legally compelled to carry under both state and federal law.
So did BNSF then haul product, if you will, into the city of Libby?
Only processed product. So there were two. So the processing plant was up the river from town. Grace brought the material from the mine to the processing plant, filtered it. Grace filtered it, stored it into silos on that property, and then there was a conveyor belt that went over the river, and BNSF had a spur track at that location where would the trains, Grace would load the trains at that point, and then it'd either take it out of Libby or there was an export plant in Libby, and there might have been two, and occasionally took it there too. But that was all processed product. That was the only product that BNSF transported was processed product that, as we state in the briefs, was tests showed was 1% asbestos or less.
Well, that's arguable.
And I think one of the issues that we can get into later, there are some disputes of fact that I think still need to be resolved. But I think one issue that probably makes all of that irrelevant is the preemption issue, and I'd like to start with that. Preemption, I think this is an express preemption case. I don't think it's that complicated, and it resolves every issue in this case. The statute 49 U.S.C. section 2106 applies the Federal Railroad Safety Act, the FRSA. It applies when the Secretary of Transportation has issued a rule that covers the subject matter of a state rule. The Supreme Court has said that when the Secretary, and it's said this multiple times, when the Secretary makes a decision, when he goes through an analysis and makes a decision not to regulate certain activity, that has as much preemptive force as a decision to regulate that same activity. Both are preempted. The Secretary of Transportation did just that in 1978 when he determined, when he looked at regulation of asbestos and the transportation of asbestos, he decided some forms of asbestos needed special extra transportation requirements. A lot of the asbestos used in construction materials, for example. But he specifically decided, after looking at all the evidence and all the issues, that transportation of asbestos, mineral-bound asbestos, for example, vermiculite, was not warranted.
Mr. Schoengert, could you address the retroactivity argument of those federal statutes?
Sure, and I'm glad you brought it up. The Asbestos Court, I think, made a mistake in relying on Judge Morris's federal decisions. Those decisions, as you'll notice, didn't even discuss the 1978 decision by the Secretary of Transportation. The reason is the exposure periods in all those cases was well before that time. It's not the case with the plaintiffs in this case. That's why Judge Morris's case really doesn't have any bearing on this one for that reason. I mean, that is the primary basis of our preemption argument is that 1978 decision, which we believe is clearly binding on the states.
Can you be specific as to what that decision was again?
The decision was to leave transportation of mineral-bound asbestos, that's the term the Secretary used, mineral-bound asbestos to current regulations, to the regulations that they were already in place, so it was treated just like wheat from Cut Bank or coal from the Powder River Basin.
Can you connect the dots then and explain how that forecloses state law claims based on injuries from asbestos?
Sure. The Supreme Court in CSX v. Underwood, CSX Transportation v. Underwood, in the briefs, the court there, I think it's page 663, said that the state law, when the FRSA talks about preemption of state law, it means state regulatory law, statutory law, and common law. So that includes tort claims. So the Secretary's decision preempts all of those. And the reason is pretty clear from the face of the FRSA. I mean, if there's any industry that needs national uniformity, it's rail regulation. And that was what the Secretary of Transportation was authorized by Congress to do, was to ensure national uniformity to the extent possible. Because you can imagine if there are a different set of rules that in Montana than Wyoming, than Washington State, that doesn't work for rail traffic, which is obviously
But is that really addressing the injuries that occurred here? I mean, what we're talking about is how this mineral-bound asbestos can be transported.
right. And the Secretary...
How does that foreclose a state law negligence claim?
Because the plaintiff's claims in this case are based solely on the transportation of this product. I mean, that's all BNSF did. That's all it can be premised on. So that activity, we're looking at that activity that's the basis of the plaintiff's claims, that's the very activity that's regulated by the Secretary of Transportation. And that's what makes it preempted. The reason is to ensure national uniformity. I think probably the best case, or the most analogous case, is this D.C. Circuit's case in CSX v. Williams, CSX Transportation v. Williams. That was the case that came in the wake of 9/11, and the District of Columbia sought to regulate hazardous material to, I think, 2.2 miles within the national capital. D.C. Circuit looked at the FRSA, found the express exemption provision, looked at whether the Secretary of Transportation had issued any rules. He had looked at whether they should reroute traffic around certain major cities. It was frankly a lot less specific regulation than we have in this case. The D.C. Circuit said that is a preemptive decision. That decision by the Secretary of Transportation under the FRSA preempts the District of Columbia from having another routing restriction around D.C. And the court said, when you've got an area that is subject to so much federal regulation, there's so much federal presence, that preemption has special force there because of the necessity of national uniformity when it comes to rail regulation. I mean, this doesn't leave railroads with a free pass. As the FRSA, that section 2106 states, railroads are still required to follow the federal standard of care. They can be sued even in tort, even in state law tort, if they violate the federal standard of care. Allegation that they did that here, but that's option. They can even be sued on the basis of their own rules and policies if they violate them, and those rules were adopted pursuant to the Secretary's authorization. So I think preemption resolves the issues in this case. Strict liability, I'd like to discuss that as well. If the court doesn't agree with me on preemption. And there's two components to this argument. Obviously, the first is whether this activity is abnormally dangerous. The test focuses on the activity. Here it's hauling, transporting processed vermiculite. Railroads have been doing that for, as I count, 70 years, and there's never been a court to hold that transporting processed vermiculite is an unreasonably dangerous activity. Federal regulator, as I just mentioned, said it's not a hazardous material. Grace submitted bills of lading with every shipment saying it was not a hazardous material. Testing showed that processed vermiculite had less than 1%, which incidentally, I want to make sure this is clear because I think the asbestos courts was maybe a little confused on this at page 3 of the opinion on the preemption issue. It talked about a 40% figure, 40% asbestos. That's the waste material. So when it's processed at the Grace's plant, the process, it's called benefaction if you've seen in the briefs. Basically, it's a process of taking bigger rocks and making them smaller rocks. So it's refining that product down. What's left over is the waste or the tailings, and that is high in asbestos. And that's the material that Grace was passing out all over town. They were using it to dry out the baseball field after a heavy rain. They were using it at the ice skating rink, the track. They were putting it in everybody's gardens. In fact, the highest reading, BNSF did extensive testing on its property and didn't find soil samples that read over 1% asbestos, except in the planter box where they had presumably used tailings. Somebody had planted some flowers with some tailings in there. That was high asbestos material, relatively speaking, but that's something that BNSF had nothing to do with.
What was the content of the asbestos at the rail links in town?
The rail links, somewhere between trace and 1% is what BNSF testing showed. And if you look at Exhibit 9, I think it's appendix pages 193 to 197, it's got the results, because Grace did its own testing, the EPA did its own testing. EPA, I think, tested almost 49,000 soil samples. And if you look, it's got visuals in that. That's the expert report of Dr. John Kind. It's got visuals of shows what the results of those tests were and where they were. They were not clustered around the track. The highest readings were, in fact, away from the track. It shows that this was clearly a problem in Libby, Montana. We all know people from Libby. We know it's a huge problem, but it was a problem created by Grace and primarily because of the tailings that it had distributed around town. At the very least, on this question of whether it's an abnormally dangerous activity, there are serious questions of fact. Now, I understand that that is a question of law. We're not disputing Chambers' decision on that. But the underlying facts on what the activity was, what the material was, there are some major disputes of fact on that. And I think it was error for the asbestos court to grant summary judgment on the basis of those facts. And this court's decision in Covey v. Brishka just this term, as I read that decision, that was the decision with the 4.5 million gallon pond up on Whitefish Mountain. There was resolution of fact. There was live testimony. Before the court made a determination, the legal determination of whether that activity was unreasonably dangerous.
Mr. Schoengert, the argument in contrast to that is that it's an interpretation of the facts, that the facts are not in dispute. The record was there in front of the court. It's the interpretation of those facts.
I think if you I understand my friend's argument, but if you compare just the expert report at Exhibit 9 and the expert report at Exhibit 33, it's hard for me to see that is anything but disputes of facts on everything from BNSF's knowledge. BNSF had no knowledge that there was asbestos content in vermiculite. In fact, let me make clear, the Secretary of Transportation's regulation is still in effect. I mean, after 40 years and a lot of research on asbestos contamination, that's still the way it's supposed to be transported, just like wheat, just like coal. And so I think that's an important point. But there are several disputes, even if you just take the asbestos court's pages 3 to 4. I mean, I think there were over, in the whole opinion, there were over 30 cites to the plaintiff's witnesses and expert. There were none to BNSFs. I mean, and if you look at those exhibits, and we detail that a little bit in pages 7 to 12 of the reply, there's some major disputes of fact on that issue. But I'd like to turn to the common carrier exception under 521, because frankly I think that makes this issue somewhat irrelevant, because the common carrier exemption, I think this again speaks to the importance of national rail traffic. The drafters of the restatement of torts, I mean, after all, they were summarizing the common law. And their summary of the common law is that, you know, we have certain activities we hold people strictly liable for. Common carriers don't fit that mold because they're legally required to carry whatever is presented to them, even if it's hazardous material. And I mean, you look at 49 USC section 111.01, it's very broad. They've got to carry anything that's presented to them if they're at all able. And so the drafters of that restatement, and every court to look at this question in the last 35 years that I found, and there have been a bunch, have found that those, as the Ninth Circuit said, Section 519, Section 520, Section 521, the exemption for common carriers, those are meant to be part and parcel. And it's not, Montana has, you know, some precedent on it. It wasn't cited in the briefs, and I apologize for that, but I want to cite a statute because I think it's important. MCA Section 6911-107 for carrying freight stipulates the standard of care is ordinary care and diligence. This court's decision, a 52 decision, Harding v. H.F. Johnson, 255 P. 2nd, 111, recognized the same thing where somebody was carrying gas and was arguably negligent in carrying it, and they held that common carrier to the reasonable care and diligence standard. There are two courts that have gone the other way. One, Chavez, the Federal District Court in California, 1976 decision. The court was trying to guess what California would hold. It guessed wrong. California later adopted the entirety of that section, including 521. The other decision is the Iowa Supreme Court, which acknowledged the logic of the exemption, of that recognition by the restatement of an exemption for common carriers, but nonetheless applied this risk distribution analysis, which was popular at the time in 1982, but not a single other court that I found has followed that. And it stands to reason. I mean, if we're going to say common carriers, you are legally bound under both state and federal law to carry what is presented to you, it makes no sense to hold that carrier liable, strictly liable, if something goes wrong. Now, it's obviously still subject to the normal negligence rules. It's subject to reasonable care, and so it's not like it's a free pass or a standard list. We're just not going to hold them to strict liability. And I think that in large part goes to the reason we have strict liability in the first place. We have strict liability because we don't want people building 4.5 million gallon ponds up the hill from their neighbor. There are things we want to discourage, and strict liability is a way to do that, and it's the way courts of law has always done it. That's not the case. It's just the opposite with a common carrier fulfilling its duty under the law to carry whatever is transported to it. We not only want them to do it, we compel them to do it. Each of us, every business depends on it.
Mr. Schoengert, are there any issues of fact about whether there were other activities of BNSF that fall outside the common carrier exception?
I don't think there are, and this is why. Because the plaintiff's claims are based on the transportation of vermiculite. That was the duty that BNSF had. That's the basis of the plaintiff's claims. There are other things that the plaintiffs have cited, and I think the Asbestos Court cited: contracts, rights of way, the spur track, helping find other avenues for a product. All those things are things that common carriers, frankly, do every day, whether it's BNSF, Union Pacific, FedEx, J&B Trucking. They all are doing those things, and part of it is because, spur track, for example, that my friends have made a big deal of. There are spur tracks all over the state of Montana and all over the country because BNSF doesn't load its own trains. That's the responsibility of the manufacturer.
Well, the last thing you mentioned was helping find other purchasers of the product. I mean, you didn't say it that way, but that's what I gather from your response. Is that a carrier's common function?
It is, and I think, departments and common carriers, especially ones that are larger and doing this all the time, they're going to find efficiencies, better routes. That if they have other outlets, that's a common thing. Now, none of those activities, and they're kind of vague in the record anyway, but none of those activities are the basis of plaintiffs' claims, and I think that's the key point. The basis for plaintiffs, there's no evidence in the record to suggest that that is not common.
But the issue isn't whether it's common, is it? I mean, the issue is whether it's legally mandated.
And that's right, and it's not legally mandated. And if liability flowed from something that they were doing that they weren't legally mandated, sure, then that's a different story. That's not the case here.
And I think to follow up with Justice Baker's question, though, that is a factual issue as to what would be subject to the public duty of a common carrier and what activities were taking place here that maybe fell outside and BNSF could be strictly liable for.
If there were allegations in the complaint that went to that, I think it could. But that's just not the case here. I mean, the plaintiff's claims are premised, at least as far as BNSF is concerned, is their transportation of product. I mean, it's not going to be, there wasn't any liability they had for, contract or a spur track or any of those things. It was the transportation of this product that is heavily regulated by federal law and that they are compelled to do. I don't see anything else in their complaint that is the basis of their allegations. I'd like to touch on Section 127, 703 briefly. The argument here is that essentially, you look at this statute, obviously the court has not looked at its constitutionality. It has invited the court to do that. It hasn't been briefed. The Attorney General hasn't been given notice. We're on a writ, which the court's already twice avoided or declined to address the constitutionality of this particular statute on a writ. But the argument here is that this is premature. Summary judgment for this statute, which contemplates trial, contemplates a settled third party at trial. It's premature to say that that can be decided on summary judgment. For example, Grace, for its part, is a settled party in this case. They've put billions of dollars into trust to settle all claims, future and present. The plaintiffs have filed claims. They're in the process of being settled parties. They will eventually be settled parties. I think nobody has any doubt about that. And if they become settled parties in a month, that all of a sudden that becomes relevant. It's only ripe at that point of trial. If for some reason that they're not a settled party at the time of trial, plaintiffs can file a motion to eliminate. It can be resolved in a number of ways at that point. We can do discovery. The case could be stayed. But clearly, they are going to be settled parties even if they are not yet a settled party. And so that's the argument. Otherwise, we're going to be back up on a writ if they are a settled, if the settlement goes through with the trust in a month, and that requires additional resolution. And the importance of, it's hard to talk about asbestos contamination in Libby, Montana without talking about W.R. Grace. I think the baseball field example that the plaintiffs have brought up, and you'll see that there's a picture of it in the handout that they've given, it's an interesting example because they want to charge BNSF for liability for running trains. Somebody built a baseball field next to a rail yard, and the rail yard runs trains. Yet they don't want us to be able to talk about Grace providing tailings, the waste product, the high asbestos waste product, to dry out the field after a heavy rain.
Well, but can't you, it seems like there's a difference in our case law recognizing different causes of a plaintiff's condition. The Truman line of cases where we've allowed subsequent or pre-existing accidents or injuries to be offered in defense of lack of causation, and a party's contribution to a single there's no question that the cause of the plaintiff's injuries here is asbestos. Can't BNSF still offer evidence that it didn't spread asbestos on the baseball yards without bringing in, I mean, BNSF could still talk about its own conduct, just as you described earlier, that BNSF's conduct was limited to receiving the vermiculite in the form that it was provided and transporting it, without talking about Grace's big involvement in the whole community.
I think that paints an incomplete picture. I mean, I think, I think it deprives BNSF of a defense, and frankly, I think it raises due process issues, and that's one of the things that I think this statute helps remedy. I mean, obviously, we can talk about Falconbridge too, but in my view, this statute controls. In Falconbridge, it was only the common law. There was no statute in place at that time.
So
Go ahead, sorry.
Mr. Schoengert, the creation of the Chapter 11 trust is an admission of liability on the part of Grace.
Right.
And I guess I'm not so much stuck on the settled party issue. I want you to address the immunity issue in the statute that provides that the exception is not applicable to a person who is immune from liability.
And just so we're on the same page, could you?
27-1-7036CI.
So the first clause of that is except for persons who have settled with or been released to the claimant. That is the key clause in that statute. So that they're not. First of all, I think the statute is referring to parties that have that are on the jurisdiction or maybe a governmental official that has immunity, but it does not apply to parties that have settled. And so I think that's frankly the quick answer to that question. And the statute, I think, was balancing some interests here. I mean, you've got this court's decisions in Newville and Plum. There were substantive due process cases, rational basis review, a fairly low bar for the legislature to meet. They looked at the court's decision and said, okay, the court identified several procedural problems with allowing a defendant to bring in a third party and put them on the jury form as a surprise to the plaintiffs. They remedied that by requiring notice. They limited to settled parties, so these are not strangers to the litigation.
So that goes back to your point, though. At this point, I mean, it does have settled in the past tense.
Yes.
I mean, at this point, do you think it's either subject to a motion in limine if, in fact, they have settled prior to trial, or are you contending that because settlement is essentially inevitable because of the trust, that it should just be applied prospectively?
I think, in my view, is that it's not even ripe either way. I mean, that's not a ripe question whether there's a settled party until the time of trial. Now, if they're not a settled party at the time of trial and plaintiffs can show they weren't dragging their feet, plaintiffs can then file a motion in limine and say that has to be excluded because they're not a settled party. We're not at that point. So my view is that summary judgment is not the right vehicle to decide that question. But I do think that it's important to be able to, and I think that was the legislature was looking at, that it's important to be able to present the whole picture. And if another party caused a party's harm, the defendant should be able to say that. I think there's not only a statutory right to do it, I think there's a due process right to do it.
Well, speaking of the procedural issues, I mean, how has BN complied with the procedural aspects of this statute?
So the state's a settled party. It gave the state notice under Section G, subsection G, I think if I'm remembering right. Grace is not yet a settled party with these claimants. In the process of settling, as soon as they do settle, BNSF will give them notice of that. And obviously, plaintiffs are on notice that we intend to do that, or they wouldn't have filed a motion to dismiss or a summary judgment on the issue.
So to follow up with what Justice Baker just asked, BNSF has not given any notice with respect to W.R. Grace.
It hasn't yet that I'm aware of anyway. I mean, I haven't seen that in the record, and my understanding is because the claimants haven't yet completed that settlement with the trust. As soon as the trust,
So what if we were to take the position that the trust was a settlement?
it
And
is.
where does that leave BNSF?
So I think you're right. I think that the trust was a settlement. I think for Grace, that was certainly Grace's intent. That's why I said, for Grace's part, it's a settled party. The statute refers, though, to the claimant, so with whom the claimant has settled. And the claimant, our plaintiffs, have filed claims, they just have not been finalized yet. And that's, so if you read the statute, you have to have both parts of that. So it's Grace is settled, and, because of the bankruptcy, it's a slightly unusual, but I think it fits pretty neatly nonetheless, especially as soon as that settlement goes through.
Well, Mr. Schoengard, at the point that these plaintiffs become settled, and BNSF is arguably a settled party, I don't see how 271703 applies to strict liability claims at all.
It doesn't.
So then why, or on what basis then, can are you saying that the railroad doesn't have until, in regard to the negligence claims, doesn't have to give the notice until the final settlement with these plaintiffs?
That's when the statute is triggered, when the claimants have settled. And if you look at, I think it's subsection 6, that's the language the statute uses. It's with whom these claimants have settled. The settled parties with whom these claimants have settled. So that's the trigger, at least as I view the statute.
Okay.
If there are more questions, I'll reserve the remainder of the time for rebuttal. Thank you.
Mr. Sullivan.
Good morning, Your Honors. I'd like to cede 5 minutes to Mr. Koch, who will be presenting on behalf of MTLA. I presented a handout containing our exhibits. The Asbestos Court found that there were no genuine issues of fact material to the legal question of whether BNSF was engaging in an abnormally dangerous activity vis-a-vis its operations in Libby. The predicate facts that underlie that determination are unrefuted. Specifically, facts reported in the EPA documentation and the historic Grace reports are not in dispute. They were not objected to below, nor was the report issued by Dr. Hart, which relied on those sources. If I could direct your attention, please, to tab 1 of our handout. The key facts are documented in the EPA 2003 initial pollution report on the Libby rail yard, which was issued more than a decade after the asbestos transport activities that Mr. Schoengart were just referring to ceased. As detailed in that report, it's unrefuted that in 2003, quote, asbestos, a hazardous substance, is present. It states that it's unrefuted that there was still visible vermiculite throughout the rail yard. And to the point that one of the justices asked earlier, it was, quote, asbestos levels in the soil from 2 to 5%. Next, the unrefuted evidence shows asbestos levels at 7 to 14 fibers per cc during the performance of routine maintenance activities in the rail yard. That is 100 times the safe workplace standard under OSHA, and as is pointed out in the record before you, it is more than 150,000 times greater than the EPA's identified level of safe community exposure to Libby asbestos. And it's unrefuted that it got there because, and I want to quote, because asbestos-contaminated materials were hauled and shipped through the rail yard and spilled into the soil for decades. That's right. This asbestos-generating condition is indeed measured in terms of decades and millions of tons, because it's an unrefuted fact that for more than 40 years, BNSF rail cars were loaded with over 500 tons of asbestos-contaminated vermiculite and hauled into Libby every day, which resulted in hundreds of millions of pounds of asbestos being hauled into BNSF's rail yard in downtown Libby. It's unrefuted on the same factual record that the EPA ordered the asbestos contamination removed. And I would then point out that why. The question is, why was it ordered removed? Because as this EPA document that was unobjected to and is unrefuted determined that it presented a, quote, imminent and substantial endangerment. I'd like to refer your attention next to tab 2.
Mr. Sullivan, before you do that, is there, it seems like we're kind of talking about this spur in one whole, as one whole organism. Is there a difference between putting the asbestos onto the railroad cars, at the processing plant versus in town and at Libby? And are we blurring everything? When you cite those numbers, are those the numbers that are in the rail links in town?
Yes, in town, Your Honor.
Okay.
And my friend, Mr. Schoengert, would have you believe that this case is about the transport of vermiculite, which of course it isn't. Our case is about the casting of toxic asbestos dust into the community of Libby from the rail yard caused by any disturbance of the dust. That could be the wind. It could be the maintenance activities that the EPA describes. It could be the switching of cars in the rail yard, or it could be through the passage of through cars through the rail yard.
But isn't the switching of cars and a lot of the activities that you've just described, I mean, that's part and parcel of the transportation?
Not the activities I'm referring to. The activities that I'm referring to had nothing to do with the common carrier's duty to transport. To the contrary, they weren't fulfilling that duty, Your Honor, and I'll speak to that more in just a minute. But what I want to say is that based on the unrefuted facts, you get a sense of what that condition was in the downtown rail yard. Because it was so toxic, as you'll see at tab 2, there was an effort made to vacuum up the toxic surface. And what were those workers required to do? They were required to wear air-controlled respirators and Tyvek suits as provided for in the health and safety plan. But that effort failed. Even after attempting to vacuum up the large rail yard, the 20-acre rail yard in downtown Libby, they determined that there was still 2 to 3% asbestos present in the soil.
But Mr. Sullivan, I guess the question that I'm hearing and stuck with myself is, for preemption purposes, whether all of the casting about of the asbestos in the rail yard was part of or incidental to the transport of that on the rail cars, and why the statute and the Secretary's decision don't trump the state common law on that.
Well, I think it's important in the first instance, Justice Baker, to understand just what are the conditions that the asbestos court found as a matter of law represented abnormally dangerous conditions. So that's what I was trying to draw based on the unrefuted record. So there's no dispute over these basic facts that are set forth in the EPA documents, that are set forth in the historic race documents. We're not dealing with something that needs to go to trial over whether or not these conditions pertained. They did, they're unrefuted. But the issue here then turns to this.
Mr. Sullivan, comment on Mr. Schoengert's comments regarding Mr. Kine's report and his findings that in fact the levels were lower. Is that a disputed issue of fact then? Or?
It isn't, Justice Shea. There are no issues of fact in regards to these historical documents. What he is talking about, what Mr. Schoengert was referring to in terms of referencing these thousands of soil samples around the community of Libby were instances where individuals in the community had taken that as soil amendments and otherwise and placed it there. So it has nothing to do in terms of the abnormally dangerous conditions in the rail yard. It could be relevant as to the issue of causation. In other words, what the asbestos court reserved was the determination as to whether, in fact, these conditions that were maintained in the railroad's rail yard caused the injuries to these plaintiffs. That's reserved for trial, and that's what that issue goes to. But returning back to the question that Justice Baker raised in regards to preemption, I would say that the cases that, it's the Easterwood case that Mr. Schoengert referred to, holds that it begins with the plain wording of FRSA's Savings and Preemption Clause, which specifically empowers states to act in an area unless and until the Secretary has issued regulations covering the subject matter of the state action. And this is the Easterwood decision that I'm referring to and that Mr. Schoengert referred to. The Easterwood court further explained that covering is a restrictive term that indicates that preemption will lie only if the federal regulations substantially subsume the subject matter of the relevant state law. And particularly, they've asserted that the state law in terms of train speed and inspection of rail car mechanical components subsume the subject of our complaints. But in order to achieve that, they would have to recast our complaint, because that's not what our case, as I've just described to you, is about. It's not the case that the undisputed facts of record establish. So I would say that our case is about the casting of toxic dust into the Libby community caused by any disturbance of that dust. It could be by wind, it could be by maintenance activities, it could be by switching cars, or it could be by through trains.
But counsel, BNSF was not transporting dust. They were transporting, according to the DOT guidelines, mineral-bound asbestos. That's their argument. So, I mean, it's like we're not connecting here.
Well, they were transporting mineral-bound asbestos in the form of the vermiculite, but that doesn't, there's no preclusive effect by virtue of that. The suggestion...
Well, but that's exactly what they're arguing, is that they were transporting consistent with guidelines from the DOT, and then I'm hearing you argue that it's which the federal standard would say that was safe. I'm hearing you say, no, this is about dust in the air, and I guess there's a disconnect there between what the DOT is saying is safe and what you're saying is unsafe.
Well, I don't think there's a disconnect there. It wasn't that the determination was made that it was safe, Your Honor. I think that the issue is whether or not, in determining whether or not that the preemption would apply, it's really, I think, based upon whether the decision is made in recognition of other existing and proposed controls, and in recognition that more concrete information was needed before specific regulations could be set. That was how the determination was made by the agency here. It was not a decision to create an area free of regulation, let alone meeting the legal standard that applies here of a clear and manifest intent to exclude state regulation. That's absent from this case and from the record of this case. I think that the case of Spreitsma that we've cited, in which, in fact, both parties cite in their briefs, supports this conclusion. There, the determination was made not to issue regulations requiring propeller guards on recreational boats, and the claim was made that that would then somehow negatively preempt plaintiffs' tort claims based on the failure to install propeller guards. However, the U.S. Supreme Court in Spreitsma found that the agency's intentional and carefully considered inquiry revealed that, as here, the available data did not, at that time, support regulation. Thus, the decision not to regulate propeller guards on recreational boats was, quote, fully consistent with an intent to preserve state regulatory authority pending adoption of specific state standards. There, as here, the Coast Guard did not take the, quote, and I'm quoting here, further required step of deciding that as a matter of public policy, states should be excluded from this area of law. And in that regard, that's why we cite to the case of the People versus Union Pacific Railroad, which underscores both of those points. The railroad argued for preemption of claims arising out of the release of calcium oxide from its rail cars on the basis that the DOT, the Department of Transportation's decision to regulate the material under HMTA in air transport, but not in rail transport, indicated agency intent to create an area free of regulation. However, in the Preemption Court rejected that argument and correctly applied the legal standard, concluding, and I'm quoting, the transportation of calcium oxide by rail is not regulated under HMTA, and the preemption of FRSA does not preclude state law where there is no federal regulation covering the subject matter. And that's the case here. We submit that Spreitsma, U.S. Supreme Court, and the People provide compelling guidance here, where the Department of Transportation also decided, Your Honor, to regulate a specific area of activity, the transport of pure asbestos to which you were referring, while declining to extend that regulation to another related area, mineral-bound asbestos, which we're dealing with in Libby. Again, I would say that this issue has been addressed by the federal court in Missoula, Justice Morris, under very similar factual circumstances. And among the rationales that Justice Morris used in rejecting BNSF's negative preemption argument was Judge Morris's recognition that it would have, and I'm quoting, the perverse effect of granting complete immunity to BNSF. We submit that the asbestos court should be affirmed. Its rationale is entirely consistent with controlling U.S. Supreme Court precedent. So, I'd also like to address this issue that was raised as to the non-party defenses by BNSF, and they will be addressed at some length by Mr. Koch, but I would at this juncture say that as was pointed out and conceded by my opposing counsel, it only applies to negligence claims. And so it does not apply to strict liability claims. And this court so held in the case of Holstein versus Lennox Industries. Even if this were a negligence case, BNSF cannot point a finger at Grace as a settled party. Section 703, subsection 6 uses the past tense, meaning it applies only when a claimant already has settled, and that, as a matter of fact, is not the case here.
Can you respond to Mr. Schoengert's ripeness argument about that point?
Well, in the first instance, Your Honor, Justice Baker, we don't get there because, as was pointed out, it applies to negligence. It does not apply to a strict liability claim.
Well,
and so you would have to get through the ruling, a reversal of the ruling of Judge Eddy on undisputed facts, and that's why I was trying to march through them in some detail, is because there, as far as the facts go.
I understand your argument on that point, and I'm just trying to save a little time, but jumping ahead, let's assume that we get to the issue of negligence. Can you respond to the argument about that 703 issue not being ripe yet because of the settlement?
The other impediments, Justice Baker, to the application of it would be the other subdivision of section 703, subsection 6C, and by reason of the Grace bankruptcy, as was discussed briefly a moment ago, Grace is unquestionably immune from liability to plaintiffs, and quoting again from the next subsection, not subject to the jurisdiction of the Montana court. as is provided
But counsel,
in the statute.
The predicate at subsection C is except for persons who have settled. So the immunity exception only applies except to individuals who have settled. So I guess going back to Justice Baker's, I mean, what is your position in terms of if claimants, and recognizing that there are a lot of them and none of them have yet, but if a claimant has settled with the trust, does that constitute a settlement that would implicate 271703?
We don't believe it would, Your Honor, for the reasons that I've stated here and in the briefing. But I would say that there's also the issue of that I would like to direct some attention to, and that's the issue of Section 521 and whether or not that BNSF can take advantage of the grant of immunity through that provision. First, as you're aware, the Montana Supreme Court has not adopted Section 521, which provides immunity for abnormally dangerous activities if the activity carried on in pursuance of the public duty imposed upon the actor is as a common carrier. BNSF has cited to the U.S. Code, which requires that a, quote, rail carrier shall provide the transportation. I submit that it's important to note that the source of the Libby contamination is not a function of common carrier duties. BNSF had no common carrier duty to create and maintain the contaminated condition on its property in the heart of Libby for decades. It had no public duty to conduct sweeping operations on its property, which blew airborne asbestos into the surrounding community.
Mr. Sullivan, don't those arguments fit a negligence theory?
I think under these circumstances, because of the substantial risk of injury, Your Honor, they actually fit the abnormally dangerous activity.
But what you're saying is that the source of the contamination was not the common carrier duties. And so if BNSF went beyond what it was required by federal law to do, then it could be held liable in negligence. Well,
Your Honor, as you're probably aware from the cases, there's almost always companion negligence and strict liability claims. The issue is really, was the exposure to Libby asbestos create a high degree of risk of great harm? The risk was inhaling airborne asbestos fibers. The great harm, asbestosis, lung cancer, and mesothelioma, these are the very diseases that the Libby plaintiffs suffer from, including one of the plaintiffs here, our lead plaintiff, Mr. Barnes. These are the very harms that Section 520 addresses. So I would say that, well, BNSF also argues, as you heard from Mr. Schoengert, that there is a genuine issue as to whether contamination from BNSF's activities actually were harmful to these plaintiffs. This goes to the issue of causation, Your Honor, and Justice Baker, that's where that nests. And that's what the Asbestos Court has appropriately reserved for trial, the issue of causation and the issue of damages. And I believe that the court's recent decision in Covey versus Brishka is instructive here. There, this court found that because the man-made pond on the side of a mountain had the potential to cause a catastrophic damage if the walls were breached, the district court, quote, properly concluded the pond was an abnormally dangerous condition which presented a great risk of harm. Here, the reservoir is the rail yard which contained not water, but asbestos, contaminated vermiculite.
And not a motor carrier.
And not a motor carrier, right.
That's the problem. We keep going around, and you know, there's a reason that 521 is in the restatement. There's a reason that there's a public duty for common carriers. And I guess Judge Eddy in her order found that Burlington had not behaved in a manner consistent with a motor carrier. And she got around application of 521. And we're still doing that here.
Yeah, Your Honor, I would submit that the unrefuted facts establish that BNSF's routine maintenance activities in the Libby rail yard released the airborne asbestos fibers into the air at hundreds of times in excess of the OSHA standard. That's of record. If you just go as far to tab 1, you'll see that that's what the EPA determined, and it was not only in excess of the safe workplace standard, but it was 150,000 times in excess of EPA's community health standard. BNSF's reliance on the EPA's documentation that there was other mechanisms of distribution of vermiculite around the community to amend soils throughout the community, for instance, does not refute the actual airborne measurement of fibers in the downtown Libby rail yard that were being dispersed into the community. They were generated by BNSF's activities in the downtown rail yard. Nor does it refute EPA's evidence of the massive amount of the contaminated vermiculite in EPA's rail yard. It was 18,000 tons, 1,800 dump trucks. That represented 40 years of contamination of soils that were transported via disturbance into the Libby community, where Mr. Barnes and the other lead plaintiffs inhaled it, sufficient to cause disease. But again, we're back to causation, and we're back to what the asbestos court said we must prove at trial. We're prepared to do so if allowed to, and we submit, Your Honors, that this is the type of case where there's an enormous record that was presented to the asbestos court. It's banker's boxes full of documents. The issue was here, someone asked, well, what about in the case of Covey versus Brishka? In that case, I've looked at the entire record. There was virtually no record there that the district court had available to it on which to rely. Here, the substantial EPA documents, the substantial Grace historic documents, none of which were objected to below, provide undisputed and unrefuted facts to establish that this was and can be concluded at this juncture an abnormally dangerous condition. It is not subject to Section 521 for the reasons stated, and it would be, to adopt it under these facts and circumstances, would be abhorrent to Montana public policy. That's been addressed in the briefs. And so what I would say, Your Honors, is that this is not an instance of federal preemption. This is a classic instance where the state of Montana was doing nothing more than advancing legitimate interests that have not been preempted. If you look at the leading cases that have been cited in the briefs, Spreitsma is the important case. Ray, the case that they cite, has been distinguished in our briefing, and the People is right on point, and all of those cases support the conclusion that preemption does not apply here. These injured plaintiffs should be allowed now to proceed to trial. Chief Justice?
Thank you, Mr.
Thank you.
Mr. Koch.
Mr. Chief Justice, members of the court, MTLA thanks you for the opportunity to be heard on this case, both in writing and very briefly here today. I think that we should maybe start at looking at the purpose of tort law, which is hold those responsible who cause harm, and that protects all of us from future harm. And it's also, they do that by compensating for injuries. And it has long been the policy, the public policy of this state, when two or more people combine to create one injury, that they're both responsible. And there's an old case, 1930s case, where it says the injured party may recover against one or all. Interestingly enough, that case is Black versus Martin. It was argued by people who became eminent jurists, Lester Lobel, Hugh Adair, and the original James Poor. Here today, what the railroad's trying to do in their causation argument is shift responsibility to Grace and avoid accountability by blaming a party that is not an entity. It's well settled that our Constitution prohibits attributing fault to non-parties, Plum and Newville. In response to those decisions, the legislature did adopt 27-1-703, whose constitutionality is not at issue here today. It allegedly set forth procedural protections to address the Plum and Newville prohibitions, but it's simply not applicable here. It clearly refers to negligence cases and only negligence cases. And as this case is before the court today, the only claims are strict liability claims.
Perhaps you could address the ripeness argument that Mr. Schoengert made
Well,
about the immunity and Grace not being a settled party yet and all that, assuming the case gets to a negligence phase.
well, if it gets to a negligence case, you got a different argument, of course, but it still does not appear, they certainly have immunity, and this court, or this Asbestos court, or none of our courts have jurisdiction over them once they file bankruptcy. The settlement, a settlement is a lot different than filing a claim. And I'm not part of the Grace bankruptcy, but if I got a settlement every time I filed a claim, life would be much better than it has been, and it's been okay. But filing the claim is not the same as settling the claim, and the claim has to be approved. There has to be proof that Grace was a substantial factor in causing the problem.
Doesn't that already exist, Mr. Cox? Doesn't that already exist, the fact that Grace is liable? I mean, that's why the fund has been set up.
Well, Grace is liable for the injuries it caused, certainly. But I don't think it's been established that they are liable to these plaintiffs. I don't know that for sure, though. I don't think so. I think the claims still have to be proved. And you may correct me if I'm wrong, but I don't believe filing a claim in the bankruptcy court is the final answer. It has to be approved by the court before it will be settled. So there you go, my time is up.
Thank you, Mr. Coe. Rebuttal.
Thank you, Mr. Chief Justice. I've got two primary points in rebuttal, and of course,
Let me just ask you to just quickly clarify. So what you're really talking about is this negative preemption argument in terms of the preemption.
I don't call it negative.
I know, I noticed you didn't.
And look
That's
at
why
Ray.
I'm asking the question.
Well, you look at Ray v. Atlantic Richfield, and it doesn't call it negative preemption either. Because the reason is there is an express preemption clause. I mean, in fact, if you look at the title of the statute, it's preemption. I mean, that's it. And so I don't think it's negative preemption. And it's not preemption from silence. That's distinguishes the case, the people case that Mr. Sullivan mentioned. That case, the California Court of Appeals said, look, I think they were trying to regulate chloride or some chemical. And the court said, okay, or the defendants, argued that, listen, federal government gets to regulate this, it regulates some things similar to it, but there was no determination by the Secretary of Transportation. There was no weighing of balancing. Instead, they were trying to argue that from mere silence that had preemptive force. That it doesn't. And so I don't think people is an extraordinary decision. Spreetsmith, which is obviously very different than we've got in this case, where we've got the Secretary of Transportation actually considering whether to impose regulations on this exact form, which I think is undisputed, that Secretary was talking about mineral-bound asbestos, which includes vermiculite, and decided that was not warranted. That, again, point to the D.C. Circuit case.
What about Judge Morris's comment that basically leaves it with a grant of immunity? If you're going to say the Secretary is going to say, well, we're not going to regulate it, but then the inference being then that there is no culpability for any, I mean, if you assume that there was harm caused by this, that there's no culpability for it.
2 points, Justice Shea, and I think Mr. Sullivan touched on the first one. In the order, in the agency order, it referenced other agency regulation of this material. It's not like it's completely unregulated. The industry is heavily regulated. Even, wheat out of cut bake is heavily, it's regulated. They're regulated how they transport that material. It just wasn't going to be subject to any additional regulation. Second, the express preemption clause itself leaves open the causes of action, state law causes of action, if the railroad violates the federal standard of care or violates its own policies and rules. And it has another safe harbor provision which has certain criteria that allows states to regulate if they're distinctly local issues, don't have an effect on interstate commerce. And I think the best case for that is I can remember it, it's the Oregon case involving train whistles that Southern Pacific Transportation v. Public Utility Commission of the State of Oregon. And that was, the federal government had regulated the decibel levels of train whistles, but they said, there's no regulation of the frequency of train whistles in high population areas, and the court said the state of Oregon could regulate that. It's a distinctly local issue. Very different case than here, where we're talking about transportation of freight.
So you're not contesting that BN owned and operated in the rail yard itself?
Correct. No, the town built around that rail yard. The rail yard had been there since the late 1800s. So, no, it had been operating, and that goes to one of the points I want to make. All I heard was the stuff that is part and parcel of what railroads do. That is the basis of plaintiffs' claims. Those are the things that they are, the very things they're compelled to do under state and federal law are the things that plaintiffs their claims are based on.
They make a claim about failure to maintain, I think, that the way that the railroad handled the material outside of the actual transport of it gave rise to injuries.
I don't see any allegation about that in the complaint. I've not seen it in the briefs. I don't see any allegation that suggests that they were handling it in any way that is different than what is required under federal law.
Mr. Schoengart, their claim is based upon airborne dispersal of dust out of this rail yard, correct?
Out of the rail yard, the rail cars, and I think that there's some spillage when this happens, as any.
And it's undisputed as to the toxic levels of asbestos in the rail yard. Is that not correct?
That is very highly disputed, and that was my second point.
I don't understand how you can say there's a genuine issue of material fact that there wasn't unsafe levels of asbestos in that rail yard.
Because if you look at the document that they cite, it says a total of 22 surface soil samples collected along the railroad tracks in its rail yard ranged from a trace to less than 1% fibrous amphibole asbestos by weight. I got some other sites. This is a highly disputed fact. Exhibit 8, Grace's own documents show that it's less than, the processed vermiculite was less than 1%. Exhibit 1.
It says what? I'm sorry.
The processed vermiculite that was less than 1% asbestos. Appendix page 191, that's the John Kiner report again. There were examples, so the hazmat suits that the guys had on, they were testing that, of course, while they were doing it, all registered in safe levels. There were all the samples at the rail yard, and this is detailed at Appendix 190 to 192, I think, that those levels were 1% or less. That's what we think the evidence shows pretty clearly, but that is a highly disputed fact. And I'd also pointed to Exhibit 1.
The bottom line is your factual assertion there is that there were not unsafe levels of asbestos in that rail yard.
That's correct. Now, for preemption, I don't think it matters whether it was 1% or 7%. It's still covered by the Secretary of
I'm not talking about preemption. I'm speaking up more to this issue about the strict liability abnormally dangerous activity and what the essence of the actual substantive claims for relief are.
That's right. Our claim is that the content, the tailings of this product are very, very different than the processed product itself. And if you look at Exhibit 8, Grace's document that measured this in 1979, I think is the earliest date, is less than 1%.
And so EPA required them to go clean up something that wasn't toxic at all?
They agreed to clean it up. BNSF was
What did they
proactive.
agree to clean up?
The visible presence of vermiculite. So, obviously there was a big scare at the time, but they did multiple samples, and this is again in the Kind report, multiple soil samples as part of that process, and none of them detected, the soil samples detected more than 1% asbestos. And I really encourage the court to look at appendix page 188 to 197 for the full picture.
What about, just to go back to Justice Rice's point, if we're talking about, and what Mr. Sullivan said, it's decades of buildup of asbestos and essentially a failure to remediate that over the course of those decades. And if the allegation is the presence of that in the yard as opposed to the transportation, granted, it spilled off the cars, I get it, but is there a distinction between the maintaining of an unreasonably dangerous condition there with kind of like the pond in Covey, that because of the buildup in the yard as opposed to it blowing off the cars and people inhaling it from the transportation of it?
Well, it's still low asbestos, it's still processed vermiculite. That's what we're talking about. It's a processed product. It's still complying with its federal mandate and state mandate to haul that material, and no one is saying that it did it in a way that violated the federal requirements for hauling that product. And if there was buildup, it's still going to be less than 1%, regardless of what the buildup is. Sure, there's going to be some spillage. That's part and parcel of what railroads do, and that's what their job is, whether, like I said, it's wheat, coal, or vermiculite. I'd also like to just address Spreetsma really quickly, because Mr. Sullivan mentioned it. That case didn't involve any statement by there was no Secretary of Transportation or any other, I think it was propellers in that instance. There was no analogy that we have now. In fact, the federal government came in on the side of the plaintiffs and said, yeah, that's not what the rule is. Very different situation than we have here.
Thank you, Mr. Schoenberg.
Thank you.
Thank you to all counsel. That concludes the argument on this matter, and we will take it under advisement and issue an opinion in due course.